to our first episode of Legal-Eaze, which is a podcast series and YouTube channel designed to making the law accessible to South Africans through various conversations with different guests that we'll have here. Legal-Eaze is a podcast series and YouTube channel which is centered on making general principles of the law more accessible to members of the public who often find themselves lost and confused when faced with a legal predicament. It also aims at making complex legal topics accessible to lawyers through conversations with experts in the field. So, welcome today our two guests with us on the panel are Siseko Salela. Siseko's an advocate at the Johannesburg Bar. He's been an attorney for many years, and prior to that, he also worked at the Competition Commission. Welcome, Siseko.
Thank you, Nicole. Thank you for the invite.
And our second guest is Mbali Mate, who's currently in the process of becoming an advocate. She's also been an attorney for a number of years and worked at Legal-Aid at some point. Yes. Welcome, Mbali.
Thank you for having me.
And I'm your host, Nikhil Deeplal. I'll always be the host, but yeah. So, Legal-Eaze is language which is used by lawyers in courts and in legal documents, which is often difficult for ordinary people to understand. In this podcast series, it will be given a new meaning. The idea behind Legal-Eaze is to break down the stereotypes surrounding the law by making it easy for most people to understand. The channel will include 30 to 40-minute discussions with various legal professionals on a host of different legal topics. Some topics will be more theoretical and focused at practitioners, a limited few, while most will be more practical and will be focused at the public at large. Each episode will have a particular target audience that guests on the panel and the conversation will be geared towards. The creators are always thinking about how we can take something which South Africans have given up on and make it relevant to them once again. And what is the benefit of the law and arguably the best constitution in the world to the man who most often cannot afford the fees of a lawyer? Whether one is a lawyer, a law student, or just someone who's interested in the law, this podcast is for you. We will give you the tools you need to understand the law and how it affects you. We believe that everyone has the right to understand the law and to access justice. That's why we're committed to making the law more accessible to everyone. So our first episode is an introduction to the legal system, and it really is about that, an overview of how does the legal system work in South Africa. We often talk about a constitution and we talk about various things, but to the man on the street, what does that mean? Now, most people in South Africa don't understand the legal system, or most often than not, South Africans know or hear about this glorious constitution, but have no idea how it operates or how it benefits them at all. This episode is focused towards a man on the street, one who has no idea about the legal system. It is a practical episode which guides people through our legal system from the bottom all the way up to the top. It's the episode that we can share widely with as many people so that they can have an understanding of the law. So let's kick off there, Siseko. Tell us what is the Constitution and what value does it have to any of us?
Thank you, Nicole. As everyone knows, the Constitution is the supreme law of the Republic, and any law or conduct which is inconsistent with it is invalid. The Constitution offers a wide spectrum of rights, and through the Bill of Rights, and also it offers how Parliament, for instance, must be set up, the powers that the President has to many other things which govern government and the society at large. Through, for instance, also when I talk about the Bill of Rights, the right to life, the right to education, equality, the right to labor relations. So those are all the rights which are offered by the Constitution. So it benefits people in that way.
So I see you have a constitution next to you, Siseko. It's quite a small document. How does such a small document govern the whole country?
Well, you know what they say, that dynamite comes in small packages. So as small as this constitution is, but it's definitely a dynamite. So to answer then your question is, it through the sections, it then dictates as to how firstly Parliament must be run, and what consists of Parliament, what consists of government, and what are the obligations and powers that the government has. And then it basically, and also how the democracy at large must be protected and must be exercised.
Okay, so we have rights in the Bill of Rights, which we know about. How do these rights come about practically in society?
It's well through legislation. It's through legislation because the constitution itself, on its own, doesn't say as to how to get to implement and enforce these rights. So then it's enforced through legislation. For instance, I'll make an example. For instance, the right to children, for them to have parental care and basic education through the Children's Act, which gives effect as to how does the custody of children happen, what are the obligations, how does parental care work also. And also another example would be, for instance, the Constitution affords the right to fair labor practices. And how do you do that? Through the Labor Relations Act. The Basic Conditions of Employment Act also dictates as to how do you then enforce this right and how are those rights protected. So it's through legislation in which our rights entrenched in the Constitution are enforced and implemented.
So the Constitution is the overarching document, and we have legislation which then gives rights, gives life to the rights rather, and tells us how to practically implement them
And did so.
access them.
And did so. And also through Chapter 9 institutions, which also guide and protect these rights, which we'll later get into.
Okay, yeah.
in our
Let's.
conversation. Yeah.
I mean, one of the important things the Constitution does talk about is access to courts. So let's go into that, because most people want to know, well, if I have a right, how do I access that right? How do I enforce that right? And that's generally through the court system. So Mbali, can you tell us what's the most basic level of one accessing their rights in the courts?
Thank you, Nikhil. Okay, there is something called a small claims court. This is for any claims that any individual may have against any other individual or against any company for a claim, the value of which is 20,000 Rand or less. A person claiming through the small claims court does not need an attorney. You can just approach the court, the clerk of the court. They will provide you with the relevant forms. You fill them in and you lodge your claim through the court. And then how you know which court to approach is that it has to be the court where the person that you are suing resides or runs business, for that particular court to be able to entertain your claim. And then it can actually be, any person can bring a claim. A person with a legal standing, this means that you must be of the correct age. If you're underage, 18 years and above, if you're underage, then you'll need an older person to assist you bring your claim.
And I mean, if you take your claim there, you'd get a decision, and which would be made by a commissioner, if I'm correct.
Yes, that's correct. You get it's called a judgment, actually. You get judgment, and you can enforce it following the rules of the court. And in fact, an example of a claim you can bring is for if you're claiming compensation from a person or any monies that are owed to you, then you can claim. What happens is that, in fact, most of the time before you approach the court, you have to send a written letter demanding payment of the amount that you're owed. And then after 14 days, if there's non-payment, then you can approach the court and the clerk of the court assist you, and the commissioner will deal with your case and give you judgment.
Now, I'm not a lawyer. I don't know how these things work. So who would present my case, or how would... I mean, it sounds quite intimidating to be in that kind of environment.
Yes. No, that's why, in fact, our laws have made it very easy that the clerks of the court are equipped and trained to assist society in this regard. So you just basically approach the clerk of the court, any court where you want to sue, and you state that you have a claim of this particular amount, 20,000 Rand against a person, and you'd like to bring a claim. And they give you the relevant forms. And in fact, they will even let you know if your claim falls under the small claims court. So if you're not sure whether or not it's a claim that can be entertained, because small claims court is a limited court, has a limited cases that they can entertain. So the clerk of the court can actually even let you know if your case falls under the ambit of the small claims court, if you need to approach a magistrate's court.
Okay, so let's go there. So if my claim isn't in the small claims court and I need to go to the magistrate's court, what is the next step? I mean, what does that entail?
Yeah. So then the magistrate's courts will be any claim which the cause of action meaning the complaint that you have does not fit in the small claims court. For instance, small claims court cannot entertain a divorce or an eviction, things like that. Or if the amount that you're claiming is more than 20,000 rand, this is when you approach the magistrate's court, district court, firstly, where your claim, the value of your claim must be not more than 200,000 rand. Okay? Even though you are allowed, or the law makes it possible that you can approach magistrate's court in person, without an attorney. Sometimes the rules and the processes of drafting documents and knowing the requirements to be submitted to the court can be a bit complex. So it's advisable to get an attorney if you are bringing a matter in magistrate's court. What happens then is that if you either have a claim that you want to bring against a person or a company or the state, or you are being sued. So you can appoint an attorney at a stage where you are wanting to institute these legal proceedings, or immediately when you receive summons. Okay, and then your case will be decided by a presiding officer. They call a magistrate in the district magistrate's court. There's then a regional court. It's also magistrate's court, but it's regional court, just a slightly higher jurisdiction than the district court. This is where the claims of more than 200,000 rand, but less than 400,000 rand would go, including divorce matters. Okay.
So the court, the magistrate's court where you'd go would be determined on the amount of the claim.
Yes.
Unless it's a divorce, and it would go to the regional court directly.
Yes.
We don't have to go into divorce proceedings. We'll talk about that on another episode.
Okay.
But okay, and would you advise that it would be worth your while to have an attorney with you in these proceedings in the magistrate's court?
Yeah, it's very advisable because, as much as the law says you can do it in person, it gets a little bit complicated when, for instance, you have to file discovery. You have no idea where to look for discovery. You don't know what documents you need to discover. You have to, the attorney will assist you to put your best case forward, because then you don't want to lose your case because you didn't know that you had to bring something or had to show something to the court. So it's always advisable to get an attorney who's more knowledgeable on what the court requires.
Now, what if one can't afford an attorney? What are the options?
Yes. There are two options that I can actually think of. You can approach Legal-Aid Board for services. They offer services for they have a criteria, I think, where if you're earning a certain amount of money, then they can ask you to pay a certain amount of money as contribution. They are there to assist the society, but most often than not, Legal-Aid will assist you for free. And then there's also a thing called probono.org. You can even go to the internet, and then you can call them up and register with them, and then they can assist you. They can find an attorney for you, an attorney who's knowledgeable with the relevant experience in that field, whatever case that you're bringing, and they can assist you if you qualify.
There are also law clinics, and there's a whole host of other things, but
yes.
we'll leave that for another day. When you say legal aid, in criminal matters, would legal aid also step in that regard? I mean, I'm accused of a crime, I can't afford to get an attorney.
Yes.
Is that when legal aid will step in as well, or do they only deal with civil matters?
No, it's very easily accessible, even in fact for criminal matters, because each and every criminal court will have a legal aid practitioner sitting on there, waiting that if there's anyone of the accused person appearing and they say they can't afford an attorney, but they would like one, and then they can just step up and approach them and consult and see if they can take the mandate and assist them there and there.
Okay,
Yeah.
but one always has a choice of self-representation.
Yes.
Which is not advisable.
Yes.
Well, of course, lawyers would say it's not advisable, but
They say, you know what, because we want money and it's a job or whatever.
Exactly. But we'll leave that for another day. Now, once you go out of the 400,000 category, and there's certain things that might not fall within the jurisdiction of the magistrate's court. Now, the word jurisdiction means a court can hear a matter or it can't hear a matter. And if it doesn't have jurisdiction, then it has to either be heard in another court, maybe another magistrate's court in another area, example, Randburg or Benoni or something like that, or it has to be heard in a higher court or in some instances. So if a magistrate's court doesn't have jurisdiction, Siseko, what are our next options?
Then our next option would be that to approach the High Court. For also depending on the on the relief which you seek, be it is it a action proceedings, is it a motion is it a application? What is it? Depending on the, I don't want to sound legalistic.
Let's not go there yet. Let's talk
there.
about the money, because most people are going to talk about that.
Definitely.
So from 400,000 up until what amount?
There's no limit.
Okay.
There's no limit. Obviously, one has to quantify their claim, and as long as you are able to prove and quantify your claim.
Okay, so any claim 400,000 and above would go to the High Court. What other kind of claims would have to go to the High Court?
I guess it will be claims whereby you want to prevent an occurrence of something, or you want to apply for divorce. As my Mbali has said, that if you want maybe divorce, or you want custody over children, and you'd go there in the High Court.
Okay. So it seems that if smaller matters go to the Maj Court, and then bigger matters are determined in the High Court.
Certainly, yes.
Issues regarding to constitutional validity and stuff like that would also go to the High Court, but we won't go into that discussion today. So you spoke about being able to stop and prevent some things. I mean, if something's relatively urgent or something has to happen quickly in law, where would we go and what's the process?
we would go to the High Court. The High Court does allow, I would say, a person to jump the queue, and jump the ordinary way of doing things. So you would then go to the High Court. Obviously, then it's an exceptional circumstance. It's a different case, a special case, always to say. So obviously, then you also need to state the reasons as to why you are of the view that you cannot wait the normal course of proceedings, because in the normal way of doing things, you issue your papers, you get allocated a date from the court, which normally takes some time also to get to be heard. But then if then you are of the view that the harm that you are about to suffer it's so huge, and you have no other alternative, you then come to the High Court through an urgent application.
Okay. So let me make it very clear. The urgent application is not there for the taking. You got to meet a very specific set of criteria, and it's a process which we're not going to talk about today.
Yeah.
But an example would be when a child is on an aeroplane and the plane is about to take off.
Yes.
And one of the parents wants to stop the child from leaving the country for whatever reason. Correct. It's in those kind of instances where you might rush to court and say, if you don't stop this plane now, the plane's gone, and we're never going to see the child again. So it's those kind of situations that that we would. And in the High Court, who would be the practitioners? I mean, Mbali spoke about having attorneys in the Magistrates Court. Who would we need to represent us in the High Court?
In the High Court, both attorneys and advocates appear, but for an attorney, it must be an attorney who has the right of appearance to appear there. And basically, it's attorneys and advocates, but mostly it's advocates who tend to practice in that sphere.
So why would one want an advocate if they are litigating in the High Court?
I think it's maybe because of the specialized training that advocates have gone through, and it's more of a specialized training that advocates have gone to, and for them it's more their practice, the area of practice in the High Court due to the specialized training, the additional training that advocates went through.
Okay.
So I think it would be then advantageous to then get an advocate.
So another thing which is known about the High Court is that judges in the High Court have discretion. So can you tell us about this discretion that judges have and how they can exercise their discretion?
Indeed, so obviously, yes, as a judge, you as a presiding judge over a case, judges have a discretion to decide, based also on the submission, on hearing the case from both sides, and then decide as to what would be the best suitable way of resolving the matter. So it's their role as presiding officers to exercise that discretion and impartiality in terms of the cases.
So it seems as if in the Maj Court there is no such discretion. Magistrates are bound by the rules of the court. In the High Court there is a discretion where judges would consider the facts of the case and the circumstances and make a just and equitable order that they deem fit, which I think is pretty important, especially in terms of the cases you take and the level of urgency.
Yes.
Now, what if one is unhappy with the judgment either at the Maj Court or at the High Court? What happens, somebody?
Okay. Whether in Maj Court or in Magistrates Court, now we are using this language people might not understand.
Yes, sorry.
Maj Court is short for Magistrates Court, or in the High Court. If you're not happy about your decision, the rules provide that you can always bring an appeal. You apply for leave to appeal to that court that gave you the decision you're unhappy about. And if you get the order giving you leave to appeal, then you appeal to a higher court. This means that you feel either the magistrate who dealt with your case or the judge who dealt with your case perhaps did not or erred in some areas in judgment of your case, and you need another judge or another court to look at it, and you think they might come to a different decision. That is how you go about it. And then you bring an appeal to a higher court than the one that you were at, and they can decide your appeal there. For magistrate courts, for instance, you will appeal to the High Court. And if you are unhappy with that decision, with the decision of the High Court, you can appeal to the Supreme Court of Appeal. Okay? And then, yes, then you approach the Supreme Court of Appeal. And I think from there, if you are still unhappy, it's very, very unlikely, but if you're still unhappy, it happens. And then there's also a higher court than the Supreme Court of Appeal, which I think will be dealt with.
Yeah, so
Today.
let's talk about that. I mean, the Supreme Court of Appeal, as it says, only deals with appeals, and those appeals can come from the Maj Court or from the High Court, and they'd be heard by a panel of 5 judges. But if you're still unhappy, we then go to the Constitutional Court. Siseko, you want to tell us about that?
Yes. If then it happens that you're unhappy with the decisions of the SCA or the High Court, you approach the High Court on appeal. But then there must be a question of that raises a constitutional issue, and that I mean be it interpretation issues or application of the Constitution. Then it comes to the Constitutional Court so as to answer the issue which has been raised on the constitutionality of perhaps any law. Certain section of a law has been regarded as to be unconstitutional, and then it will then go to the Court for it to make that determination as to whether is it indeed really invalid or inconsistent with the Constitution. Whatever question has been raised in the previous court, then the Constitutional Court has to then confirm that invalidity or clear out that issue of which has been raised.
Okay, but that's the first element. So the first element of an appeal is constitutional validity, where the Constitutional Court will either declare an of Parliament constitutional or unconstitutional. But also you can also appeal a decision of the SCA which you disagree with.
Sure.
You still have you have access to the Constitutional Court in that instance as well.
Cool.
So you're not closed off in that sense. The Constitutional Court is now the apex court in those kind of matters.
I just want to add something here. If you are taking your matter to the Supreme Court of Appeal or higher, you definitely need the services of an advocate. As my learned colleague said, it's a specialized field of training that the advocates specialize in. And also there in the Supreme Court of Appeal, the judges, they are faced with, I think, there's a lot of work and strict timelines. So everything must be to the point. They don't have time to, like in a match court, a magistrate can take a person through and say, no, maybe this, maybe that. You know, in the Supreme Court of Appeal, it's strict timelines. It's strict rules. So they must be adhered to. And when the case is brought before those judges, it must be on point. There's no second chance. Everything must be on point. So you definitely need an advocate for taking your matter to the Supreme Court of Appeal.
Okay, great. So now we've explored the court process, and we've spoken about from the magistrates' court all the way up to the constitutional court. And we know once you get a judgment at the constitutional court, that's about it. So it ends there.
Yeah.
End of the road.
But what are the other options? I mean, Siseko, I think we started off by talking about Chapter 9 institutions. So anyone want to talk about what are Chapter 9 institutions and what role they play?
Chapter 9 institutions, the role that they play in the bigger scheme of things is to protect, to ensure that the rights which are enshrined in the Constitution are protected and, in fact, they are implemented. And they serve as an independent. They basically assist in keeping government accountable also. They're independent from government, and they assist then in terms of, as I said, protection, maintenance, and implementation of the rights which are enshrined in the Constitution.
What are some of the Chapter 9 institutions, Siseko?
We have the public protector, which then deals with any improper conduct in the government sphere, and also we have institutions like the Human Rights Commission, which also protects and maintains human rights, and also people have an opportunity to even lay complaints at these Chapter 9 institutions where you see that there's foul play here and there, or there's been an infringement of these rights afforded by the Constitution. So people are able to then lodge complaints in these institutions. And also we have issues like the institutions like the Auditor General also, which assist in auditing government departments, municipalities, and they must ensure that there is good governance in terms of finances where they're concerned. And also we have your independent, your IEC, and also institutions that govern broadcasting, like your ICASA. Yeah, those.
Okay, so it seems as if all of these institutions exist to protect our democracy.
Certainly.
And they're independent from the state. Although they're funded by the state, but they exist primarily to perform independent functions, which give rights to citizens within a democratic dispensation like South Africa. So they're quite important.
Yes, absolutely.
And we must make use of them. We must approach them and lay out complaints and test the structures of our democracy. Whether we believe that we have a strong democracy or not is another thing. We can have that debate. But they do exist. And there's also things outside of that, like alternative dispute resolution mechanisms, such as the Ombud. Mbali, anything you want to say on that?
Yes. So there's the ombudsman for most of the things. It is advisable that perhaps if you have a complaint, if you can try and find out if there isn't an ombudsman which deals with such complaints. I know there's a short-term insurance ombud which deals with disputes regarding insurances, it may be a car insurance or a house insurance, or there's also national consumer tribunals, which would deal with consumer issues. So perhaps, and you don't need an attorney to lodge complaints with this ombudsman. Also, you bring the complaints in person by yourself. It's a very cost-effective way to resolve any disputes without approaching the courts.
Right.
Yes.
So one, we just have to look at the area within which the dispute lies.
Yes.
And check whether there is an ombud that exists. I mean,
Yes.
within the housing schemes, you might want to look at CSOS, which is a community schemes ombud.
Yes.
Yeah.
You
Yes.
know, and you can take your disputes there.
There, yes.
So it's much more cost effective and could resolve some of your problems.
Yes.
So that's what we would
Without having to approach attorneys or going to court.
Yeah.
Yes.
Now, we've spoken about various things today. I mean, the last thing I want to touch on, we did talk about legal aid, but we hear this word state attorney being spoken about quite often.
Yes.
Mbali, I know you've worked at the state attorney, so you can tell us, what is the state attorney and who is it for? Is it for us citizens, or what's the deal with the state attorney?
Well, in fact, a comparison the between legal aid and the state attorney. So legal aid would represent the individual people, and the state attorney, on the other hand, is also a attorneys by the state, but it represents the governmental departments. So if anyone has a claim against the government, then the state attorney are the attorneys who represent the state by law, whereas legal aid is put in place by the government to represent the individual people.
Okay, so it's the law firm for the state, basically.
It's the law for it's not for the people.
yeah. The one for the people does exist, though. So
Yes.
yeah. Okay, so I mean, I see we're out of time. So although there's a lot more we could talk about, I think we're going to end it there. I mean, to summarize, we've gone through the entire process from the small claims court to the magistrates court, the high court, the Supreme Court, and the Constitutional Court. And we see that all of them come out of this glorious document called the Constitution, which is given life to by legislation. And that will give us guidance as to my rights and how to enforce them and where to go. Certain things have to go directly to the High Court. Others might have to go to the Mag Court and so on and so forth. But there is a system in South Africa, and the system is one that we are part of. Whether it works or not is debatable and arguable. Some say it works really well, others say not so much. But it's a system that exists, and it's a system that we must be a part of if we want to enforce our rights. So I think that's my takeaway from today's episode. I don't know, Siseko, if you have anything you want to add.
All I can say is that time flies when you're having fun.
Mbali, anything from your side?
No, actually, thank you so much for having us, Nikhil. And I hope this will assist people, and people actually grab the information that we've given them today, because now we know you don't need an attorney for everything to approach the court. You don't really need to approach the court sometimes. Yeah. So it's very valuable information that Nikhil has brought to the attention of everyone. Thank you.
Thanks, Mbali. So if you have any questions, any comments, please feel free to email us or tweet at us or get in touch somehow. Our details will be on shortly thereafter, and we hope to see you on the next episode where we'll be discussing something interesting and hopefully something valuable to you. So thanks for joining us, and thank you, guys.
Thank you.
Thank you.
That's it from our side.
Thank you.
Thank you.